Morning phlegm. Got nothing to do with health for me. Dust, smoke. Okay, let's see. Oh. Okay, Shannon, could you put us on the record? This is McConnell versus McConnell. Mr. Robert McConnell is present, as well as his attorney, Shalini Nangia.
Good morning, Your Honor. Shalini Nangia here on behalf of Robert McConnell.
Okay, and I do not see anybody here for the defendant. It doesn't look like she's represented by counsel currently, and she has not appeared. So you are here today requesting release of a judgment lien because it has been satisfied?
Yes, Your Honor. And I feel I need to be honest with the court as well. Our office had sent notice of the hearing as well as a copy of the motion to Ms. McConnell at frankly the only address my client has had for her for years. And this was quite a contentious case for many years. Ms. McConnell years ago at the time of the divorce had requested a confidential address with the court. So my client for years has had a P.O. box address for her, and that's the address he used to send all these checks for many years. In the last couple of years, those checks have been sent back. Our motion just yesterday, my office got the packet back stating that it was not deliverable to her there. So I don't really know where Ms. McConnell is. Years ago in 2016, you awarded my client full and physical custody because she was very unstable mentally, had been moving around from various places, 6 or 7 residences in a year. And she has not seen or talked to her son since that time. William is now 14 and sadly hasn't heard even or received a birthday card from his mother in all these years. So I really don't know where Ms. McConnell is.
Let me stop here. I'm going to let everyone in the waiting room in just to make sure there isn't someone there who's here on her behalf.
Okay.
As soon as I have an audio connection with everyone, I'll pose the question.
Good morning, Judge. This is Bill Huggaboom. Can you hear me?
I can. So I let everyone in the waiting room in just to make sure that I've got everyone here in the matter of McConnell versus McConnell.
That is not me, Judge, nor is it Mr. Lopez.
Hello.
Good morning.
Morning.
All right. It does not appear that there's anyone here on behalf of Ms. McConnell. I guess I'm not surprised given that we don't have a good address. She's failed to keep her address current with the court. How old is the child, Ms. Nangia?
14, Your Honor.
And is she paying child support?
She has never once paid any child support. Although, to be honest, I mean, part of my motion today, the money that Mr. McConnell owed to Ms. McConnell, he sent her checks. But on top of that, once my client was awarded custody, you entered an order that was offsetting her child support obligation against his property settlement obligation. And so between those two, he has met his obligation under the divorce judgment. So she has not technically been required to pay up until now because those payments were allowed to be offset against his obligation.
I'm sorry, I don't mean to interrupt, Judge, but should I be in the waiting room right now, or?
That's fine. Just wait until I call your case. I had to let
sorry.
everyone in to see if I had anyone out there that was on this case. So you could just mute your microphone, and when it's time to call your case, I'll let you know.
Thank you.
Well, I'm wondering if maybe we ought to do some kind of service by publication, so there's at least some attempt to notify her of what's happening here.
I didn't know if, excuse me, Your Honor, I didn't know if there was an address on record for her. I mean, she's under an obligation to keep her address current with the friend of the court. So I don't know, and because it was confidential, I don't obviously know what that address was, but I didn't know in past hearings in other courts, I have had the court send it out to the confidential address. And like I said, if you're obligated to keep that address current and you don't, then I don't know if that's.
Well, let's do this. I will check with the friend of the court and the clerk's office to see if there's any other address that she has provided. If there is, well, either way, we will notify you. You're going to have to renotice this. If I can't find another address, I think at a minimum we should do some kind of publication. Hopefully somebody who knows her and knows where she is will see that. We'll let her know. But I'm hesitant to grant the relief today without some indication that she's aware of this motion.
I understand, Your Honor.
So I will check. I'll have someone check to see if we have another address. If we do, we can forward your motion to that address, and then we will notify you. Actually, I'll have somebody get in touch with you and ask you when you would like the motion to be renoticed so that it doesn't conflict with anything on your schedule.
That would be great.
Okay. So I'm going to write myself a note, and I'm sure I'll see you back here soon.
Great. We'll plan for that. Thank you, Your Honor.
Thank you, Your Honor.
You're welcome. All right, next matter is Schaefer versus Spencer.
Good morning, Your Honor. Jacqueline Garris appearing on behalf of Mr. Spencer.
Your Honor, Michael Fallahy on behalf of the plaintiff, Bethany Schaefer. She's here in my office with me.
Okay, and Mr. Spencer, the defendant, is also present in the hearing room, Shannon.
Yeah, that's correct, Your Honor.
Ms. Garris, this is your motion?
That's correct, Your Honor. Your Honor, we were last in court this past summer based on our motion because Ms. Schaefer refused to properly count the number of days in the summer. The court found in my client's favor and awarded him days to make the summer split evenly pursuant to the party's order. Now we're here again because Ms. Schaefer continues to disregard the court's order. The one specifically I'm talking about is May 31st, 2017 order. And I want to point out that my client has just 91 overnights out of the year. That's 25% of the time. And he has to continue to fight all the time to see the party's daughter. And it's actually the child's right to have parenting time with each parent. She even states that in her answer to the motion that she disagrees with the court's decision this past year and that she thought she was right in counting the overnight. So it's going to be a continuous battle for my client until this child turns 18. Now we feel that's even more clear that she violated the court's order. And the paragraph that I'm talking about is paragraph number 4 of the May 1st, 2017 order. And it states that in the event either party receives 3 weekends in a row of parenting time due to the holiday schedule, the party with 3 consecutive weekends shall give up those weekends to the other party. That party shall give, that's giving up the weekend shall give the other party 30 days notice of which weekend they'll be giving up. This is a provision that she insisted on, although she says she didn't, but it's also a provision that she has asked and enforced against Mr. Spencer. So my client had November 20th, November 27th, and he have had December 4th. He emailed her on November 2nd to tell her that due to the fact that he would have 3 weekends, he will give her December 4th, which she took happily. And this was enough notice to satisfy that order. So again, I want to make it clear that it's the party that's giving up that parenting time. It's their burden to tell the other party of what weekend they're giving up, and they have to give 30 days notice. So then he asked for December 18th because Ms. Schaefer had December 4th, December 11th, and she would have had a December 18th, which she actually did have. He emailed her on December 10th, which was not his place to do, but he asked, are you going to give up December 18th because you would have 3 weekends in a row? And she said no. I reached out to her attorney to see if we could avoid court intervention and was told that she's standing by her position. And her position is that it's her holiday break. And that takes precedent over any other regular parenting time. Now, while that's true that holiday parenting time takes place over regular parenting time, the May 31st, 2017 order clearly deals with the party's holiday schedule. And it says right in that paragraph, due to the holiday schedule, if any party receives 3 weekends in a row. I also want to make it clear that when she gets 3 weekends in a row, she actually almost gets 4 weekends in a row, 4 weeks in a row, because he's not allowed to pick up the child until Friday. So she had 26 days in a row that my client went without the child. Excuse me. She's saying that he was supposed to contact her, that he didn't give her enough notice. It's not a valid argument. I mean, the order, again, is very clear. She had to give up one of those weekends. She didn't give up December 4th. She didn't give up December 11th. He asked for December 18th. She said, no, that's part of my holiday schedule. Well, the holiday schedule created 3 weekends in a row. So by way of an example, in 2018, she emailed him and asked if she could, because he was having 3 weekends in a row, she wanted him to give up a weekend. He had already made plans. She didn't follow the 30-day notice. Long story short, he relented. He gave in. He did the right thing and took the higher road. He changed his plans. And so he didn't take 3 weekends in a row. And again, his 3 weekends in a row is only 3 weeks in a row. She gets the weekdays in between. When she takes 3 weekends, it's actually almost 4 complete weeks. So I think we should do away with this 3-weekend thing. It creates a domino effect. It creates problems 3 to 4 times every year. The parties obviously have issues in having this provision followed. And so one of the things we would ask for is that provision in the May 31st, 2017 order be stricken about the 3 weekends in a row. My client would like to have makeup time because he didn't get to see the child. So he would specifically ask for March 12th, 13th, and 14th as makeup parenting time. Again, that's March 12th, 13th, and 14th. As far as my other parts of my motion, she admits she owes $142.79. He submitted his claim to the front of the court outside of their 90-day, outside of the 90 days. They won't enforce it. That doesn't mean it's not enforceable. The Uniform Child Support Order rules, and she's supposed to pay her percentage. So he would like her to pay that immediately. It is only $142.79, but these add up. It doesn't matter how much she earns, how much he earns or she earns. It's just according to the order. So we would like her to pay that immediately. Finally, I tried to resolve this without court intervention. This is the second time we've been in court in less than a year. I think I talked to my client about this and what we should do before we filed our motion. I tried to reach out to Mr. Fallahy to see if his client would agree. This is such a clear violation of that 2017. I mean, she's supposed to give notice. She didn't. She took her 3 weekends in a row. She's trying to argue that it's his holiday, it's her holiday, and that takes precedent. But again, the order is very clear that if the holiday schedule creates a time where either party has 3 weekends in a row, they must. It shall give up that and shall give the other party notice of which weekend they're giving up. She didn't give up a weekend, and so he went 26 days without his child. So what I'm asking for is attorney's fees of $600 plus the filing fee, $140. I have a feeling we're going to be in court more. Unfortunately, I mean, we would like not to do that. We would like to be able to work together and have these orders followed, but this is the second time he had to seek court intervention to have the orders followed.
So before I hear from Mr. Fallahy, I'm looking at the May 31, 2017 order. It appears to treat holiday breaks in a different manner than it does holidays. And my understanding, even though it doesn't look like the parties have opted to have the front of the court handbook govern parenting time because they've established their own order, but even the handbook treats holiday breaks differently from holidays. Assuming that's true, wouldn't the holiday break time preempt anything else in the agreement as it relates to weekends and holidays?
You're addressing that question to me, Your Honor?
Yes.
Okay. The way I read this, I mean, yes, normally holidays would be a precedent over regular time, but paragraph 4 addresses the fact that if the holiday break, holidays, whatever, if it creates 3 weekends in a row, then the other party has to give up one of those weekends. So regardless.
Let me read that provision again. All right, thank you. Mr. Felly?
Thank you, Judge. Just a couple points to make, and I think you raised a very interesting point, Judge, and I had that in one of our response paragraphs to the motion. Going back to this last summer's hearing, I would point out for the court, Ms. Garris her client did prevail on 1 weekend of makeup parenting time, but they were also asking for attorney fees, which was denied by the court. And they were also asking for a change of parenting time that actually amounted to a change of custody, which was clearly and quickly denied by this court. Ms. Garris's client in the motion talks about the spirit of the order. And, I indicated that these parties need to follow the language of the order, which gets back to your question that you just asked. Paragraph 4 of the order from May of 2017 only talks about holiday parenting, not holiday break parenting time. I would further point out that if we want to talk about a bit of the spirit of the order, the main reason for that paragraph actually and interestingly benefits the child and Mr. Spencer, so he doesn't need to go an extended period of time without seeing his child.
So how did it happen that he went 26 days in a row without seeing his child?
My client was of the understanding that the holiday break parenting time, as you pointed out, was different than the weekend. I would also point out, and I put it in our response, that neither of these parties recognized that this was a 3 weekend in a row type situation where this provision may have applied until it was too late. And the only weekend that my client could have given up was her holiday break parenting time. And if we want to talk a bit about the spirit of the order, the reason that this order was entered back in May of 2017 was to allow each party to have their holiday and holiday break parenting time and to give a non-holiday or non-holiday break weekend to the other party. So, this was done too late. Neither party realized it. And by the time that they both did, the only available weekend, I think, based on both parties' statements, was December 18th. And as I stated in my response, my client's Christmas, she was celebrating with her family, was that weekend because the following weekend was Mr. Spencer's parenting time and his Christmas parenting time. So, we talk about the specific language of the order. The specific language does not allow what they're asking for. If we want to talk about the spirit of the order does not support their position either. Ms. Garris talks about wanting that her client wanted to take the higher road. I haven't seen Mr. Spencer take the higher road on any of these motions that he's filed. He doesn't do that. I think a perfect example is that he's trying to seek reimbursement for $142 when he makes almost 6 figures per year. And some of these expenses were over a year old. He didn't care about them until he had some dispute or didn't get his way over parenting time. I would further point out that Mr. Spencer, at his motion in the summer, was arguing the exact opposite of what he's asking for now. And I put that in our response. He was asking essentially for the court to disregard this 3 weekends in a row, and now he's asking the court to enforce it. So, he's taking these conflicting positions, and, our response is clear. We'd ask the court to deny the motion. We'd ask the court to find that the motion is frivolous. It's not based in law or in fact. We'd ask the court to consider an attorney fee award to my client instead of to Mr. Spencer. And we would also point out, and I put in our response, Mr. Spencer isn't even following the reasonable phone contact provision from the order in 2016. So you need to come to court with clean hands. And Mr. Spencer at this point does not have clean hands. And we'd ask the court just to remind him that he needs to follow that provision in the order from 2016 as well. Thank you.
Ms. Garris?
Yes. If the May 17th, the order in 2017, the very first paragraph talks about Christmas holiday parenting time. And then it goes on about 2-week holiday break. This is about the holidays. This is about the Christmas holiday break. And it specifically says in number 4, if the holiday schedule creates the 3 weekends in a row. It doesn't have anything to do with summer. That's a different order. That's summer parenting time to be divided equally. So they're two separate, they're trying to confuse the facts by saying that he pushed for summer parenting time when he had 3 weekends in a row. That's a different issue. That's a different order. It's clear that they each get they're supposed to divide the summer parenting time equally. Different issue. This issue, we're talking about the holiday schedule that's created by the Christmas break. That's laid out in paragraph 1 and then further laid out in paragraph 4. So she took 3 weekends in a row. She's trying to put the burden on him. He didn't give her enough notice that he wanted that December 18th weekend. That's not his burden. The order is clear. Party giving up the weekend shall give the other party 30 days notice. He didn't hear from her. He reached out on December 10th. He then reached out again on December, I believe it was 14th. And I have the emails to show that he did that. Again, that's not his burden. It's her burden. She didn't give him up. So he went all this time without seeing the child. As far as what he said about my prior motion in June of last year, wasn't not for a change of custody. It was for parenting time. As far as, they say that how much money he makes, and I'm getting it that she shouldn't have to pay any uninsured healthcare expenses. I don't even know what to say about that, although there's a child support order, states the percentages of who pays what for uninsured healthcare expenses. That should be at the end of that. As far as contact, this was something they added to their response. I talked to him about it at length yesterday when I was preparing for this motion, and it's simply not true. It says regular and reasonable contact. It doesn't mean calling the child every day, every evening, texting her, trying to get a hold of her, and then trying to make her feel bad maybe about being with dad instead of mom and how much mom misses her. It should be reasonable contact. He only has 91 days. He wants to maximize that time with the child, and at no time has he ever interfered with that child's communication with her mother.
How old is the child?
9.5.
All right. Thank you, counsel. In reviewing this stipulated order from 2017, paragraph 4, I've had a chance to consider it. I believe that the intent and that's clearly expressed in it is that it's not limited to holidays or holiday breaks. It clearly refers to holiday schedule. And it also clearly says that in the event either party receives 3 weekends of parenting time in a row due to the holiday schedule, the party with 3 consecutive weekends shall give up one of those weekends to the other party. The burden is on the parent who gets the 3 consecutive weekends to preemptively indicate which weekend that parent wishes to give up. Clearly, regardless of the reason, that didn't happen here. The dad went 26 days in a row without seeing his child, and that definitely goes against the express language of paragraph 4. I am going to award a makeup weekend. If the parties cannot agree on what that makeup weekend is, I am ordering that the parties engage a parenting time facilitator or mediator with the expense to be shared by both parties. And that will also apply to any future motions regarding parenting time. You're going to mediate it before you bring the motion in front of me. I am going to award the $142.79 in unreimbursed medical expenses, but I'm denying any request for attorney fees. Ms. Garris, you will prepare that order?
That is correct, Your Honor.
All right.
Thank you.
Judge, I apologize. Did you say I was talking with my client for a quick second there. You ordered a parenting time facilitator or mediator, the parties to equally share those costs, and that has to occur before any motion is brought in the future. Is that what you said?
Before it's noticed for hearing, yes.
Okay, thank you very much, Judge.
All right, thank you.
Thank you, Your Honor.
Okay, Lopez v. Lopez.
Hey, Judge.
Good morning.
Good morning.
I've got 3 other people in my waiting room. I don't know who they are. I'm going to let them in.
I've got mute.
We're getting some feedback. I'm not sure. Who is it at telephone number ending in 1600? I just lost him, whoever it is.
Judge, that was me. I was having connectivity problems this morning.
Okay, so we have Mr. Navarre here on behalf of the plaintiff, Mr. Hugaboom on behalf of the defendant. We have Mr. Thomas Lopez and Anita Lopez all present. And Ms. Samuels, I'm not sure what matter you're here on.
For divorce.
All right, I'm going to put you back in the waiting room.
Okay.
I don't know what I did with my docket sheet. There we go. Oh, she's just early. Okay. Okay, so this is defendant's motion for exclusive use. Go ahead, Mr. Hugaboom.
Thank you, Judge. Judge, what we have here, we have a divorce filed in June of 2020. The parties continue to reside together in the marital home with their children. And at this point, we've made absolutely no progress in the case. Occasionally, my client would contact me complaining that there's been argument in the home, property come up missing, been small things, but it's been building and gathering a momentum. On January 5th of this year, 2021, my client contacted me and indicated that the plaintiff had caused an argument over 30 minutes in the house. He recorded the argument, his video of it, if anybody wants to see that. After the argument, the plaintiff left the home in a rush. She smashed into my client's car. And my client's car was parked outside the garage in its normal spot with probably 5-6 feet between the cars. Ms. Lopez continued on. She didn't stop. So it leaves us to wonder, is that she hit the car on purpose, or was she just so out of control that she didn't know what she was doing? Mr. Lopez contacted the police, but of course, because this is a marital issue, they didn't do anything, couldn't do anything. Mr. Lopez complains that there's a lawnmower that's missing. I've told him in the past, call the police, we can't find it. His driver's license has come missing 3 times. His passport, birth certificate, clothes, golf clubs all come up missing, Judge. When I look at MCL 400.1501D, It's the definition of domestic violence. It says that it's the occurrence of any of the following acts by a person is not an act of self-defense. I is causing or attempting to cause physical and mental harm to a family or household member. And what she's doing, Judge, she's constantly harassing my client. She's arguing with them. She tells him that this divorce is still pending because his fault. He hasn't done anything in this matter. I says placing a family or household member in fear of physical and mental harm. Judge, she's leaving the home, smashing his car. She's disposing of property. This is a home where my client lives on one end of the home. She lives on the other end. They don't have a finished basement for them to live in. They have to meet in the middle. My client is fearful every day of what's going to happen next. What we need here, Judge, is we need an order giving exclusive use of the home before either someone goes to jail, hospital, or worse yet, the morgue. We want to avoid any of that from happening. Further, Judge, what we have here, we met with you on December 3rd, informally, and we agreed to mediate the case. Well, Judge, Mr. Navarro, the plaintiff, they didn't follow through with that. I called the mediator that they recommended, got nowhere with that. I found a mediator in Brighton, Michigan, who had immediate dates open, was cheaper. I informed Mr. Navarro of those dates. I got absolutely no response, Judge. I have 2 sets of interrogatories. I've got no response from them. They have not answered them. Fact is, Judge, I don't trust them anymore because they've done nothing. They haven't followed through on anything. And what I think is going to be beneficial, Judge, is that you give my client exclusive use of the home, put Ms. Lopez out, allow her to come back during the day after Mr. Lopez goes to work, and she has to leave before he comes back home from work, if that's what it takes to help care for the children. That does 2 things. One, it keeps the party safe from committing any more domestic violence or escalating any further. 2, it puts Ms. Lopez on notice that they need to start cooperating in this case. We need to get this case moving forward. We're still willing to mediate it, but again, I don't trust them because they haven't followed through yet with even the simplest things of mediating this case or issuing it. Judge, we can take testimony from Mr. Lopez if the court desires to hear his side of the story on the escalating domestic violence in this case, or the court can rest on our motion here. Judge, what I find interesting in this case is I did get a response from Mr. Navarro after hours last night. Of course, they denied everything, but the timing of it is rather unique in that they've had 2 weeks and at the 11th hour, they provide a response. And they've not objected to anything, Judge. They've never objected to my interrogatories, but they don't complete them. They haven't objected to the mediation, but they don't complete it. So Judge, I find that any of their answers in that very late response to be without merit. So again, we'd be more than happy to take some testimony if the court wishes, or we'll stand on our motion. But we're going to ask that the court order Ms. Lopez out of the home and get this case moving forward. Thank you.
Mr. Navarro?
Thank you, Your Honor. Your Honor, we had emailed to our client the pleadings that had been filed by Mr. Hogaboom on behalf of Mr. Lopez. And it wasn't until a day ago that we discovered that she said she did not receive them. So we resent them. We worked on providing an answer. We emailed that to Mr. Hogaboom. I contacted him and advised him of that situation, and then I would be emailing a response as soon as we could complete that. She works part-time cleaning 2 homes, I think bi-weekly, and so he has very limited employment and income because she's taking care of the 4 kids and providing all their transportation to and from school and for all their extracurricular activities. She had to work yesterday, and so that also caused a further delay in the response. However, it is a verified response. And, Mr. Hogaboom signs the pleadings on behalf of Mr. Lopez. So my client's provided a verified answer. And if she if you want to have a hearing on this, we'll subpoena the officers that responded to Mr. Lopez's call regarding the damage to his vehicle, which was not extensive. It happened the day that school came back. I think, I don't know if Your Honor has a chance to read our response, but I did have it emailed to Your Honor as well as to the clerk. She got home with the kids. He continued to be domineering, overbearing, argumentative, controlling, to the point that the 7-year-old first grader, Mia, was brought to tears. And so she sought comfort with her mom in her mom's room, where she has been really forced to kind of self-isolate because of Mr. Lopez's conduct. What we got here, Judge, is the pot calling the kettle black. Mr. Lopez is the one who is disruptive. He's the one who is verbally abusive. He's the one that has caused my client to come to tears that evening. So she had to leave the home. And yes, she was visibly upset. She was crying. Mia was crying because of Mr. Lopez's conduct, not because of my client's conduct. She was self-isolating in the room. He got overbearing with Mia. Mia started crying. She went to her mom for comfort. And then Mr. Lopez starts the argument. So my client gets into the vehicle, starts the car, proceeds out of the garage and onto the driveway. It's freezing rain. The driveway's icy. She's got defective brakes because Mr. Lopez won't pay anything to have them repaired or replaced. She applies the brakes. The driveway's icy. The car doesn't stop. It starts to skid, and it slides into the front end of Mr. Lopez's Subaru. That's what happened. She stays in the car. He calls the police. She leaves to go get gas because she wanted to have gas in the car so she could transport the kids to school the next day. What's been going on throughout this case is Mr. Lopez is not providing any support for Mrs. Lopez. He's giving her, I should say he's paying her $27 biweekly. So approximately $54 a month. That's all that he's provided to her throughout this case. She was forced to take his bonus money in the spring to pay bills because he got behind on bills that were marital. She didn't utilize that money for anything but other than marital purposes. And you know, she has been providing and accounting for that. But what happened as far as the interrogatories are concerned, first, they were not compliant with the court rule. I objected to that. So he sent a second set of interrogatories. Mr. Lopez, in the interim, steals her zip drive for her laptop and takes all the information that she had accumulated and removed other documents from the house so that she couldn't provide the answers. She's got some of this, everything that she could reconstruct, she has reconstructed. She can provide that today. And I've requested that she do that through my office. So as it relates to that, you know, she's attempted, but he's thwarted her efforts to provide the discovery. And he actually has the information, I'm informed by my client, of what he's requesting. So it's game playing on his part, Judge. And, you know, earlier this fall, their daughter required physical therapy, which he refused to pay for. She had to borrow $400 from her parents so that the daughter could have the physical therapy that was ordered and recommended by the doctor. You know, he buys food for the home, but just for him and just for the kids. And he won't let her cook that food for the kids. He won't let her have any of that food for herself. She's got to go out and buy her own food. So that's the kind of stuff that's going on here. And to portray my client as a abuser and committing domestic violence is an extraordinarily far stretch of what the truth is here. What we think should happen is they should have mediation in this matter as soon as possible. There's no basis for her to be put out of the home other than this is another continued act of disruption by Mr. Lopez. And, you know, the example that I gave in our response was the New Year's Eve get together or a day after New Year's get together. that my client planned with the children and herself at the Reynolds house, which is the next door neighbors. Well, Mr. Lopez comes in uninvited and polishes off a substantial amount of tequila and gets drunk in front of the kids, causing the kids to be upset and causing one of the daughters to come to tears because of his conduct. So to say that my client is perpetrating domestic violence in the home and should be removed is absolutely ridiculous. Again, we want to have a hearing on this. We'll subpoena the officers. She talked to the officers and explained truthfully and candidly what the situation and circumstances were. She had to remove herself from the home because of Mr. Lopez's conduct. She had to talk to her parents on the phone because she wanted their comfort and their support because of her emotional state. But to say that she intentionally committed, maliciously damaged his car is not true. And as it relates to the items that he complains of, alleging that she has taken or she has, sold, she has sold some items, Judge. I mean, she's sold a high chair that was in the garage that's no longer used because the kids have grown up. She sold some baby clothes. She's maybe acquired about $60 of things that she has sold, but she certainly hasn't taken his golf clubs, hasn't sold anything. She does have a Mac computer, which she retains for safekeeping that wasn't utilized by the parties, but was other than for storage of photos primarily. And she was afraid that he was going to destroy those photos. And so she has that. As it relates to photos also, Mr. Lopez is engaged in conduct where there's a portrait of her mom and dad. He scratches out the face of her father on that portrait. So that's the kind of conduct that he's been engaging in, Judge. And frankly, we need to get to mediation so we can resolve as much as we can resolve in this case and get it finalized. So that's what I can say, what my client has said by verification through the answer that's been provided to the court. And I think to put her out of the house is not the appropriate answer. He is gone for the majority of the day, works a lot of hours, and doesn't come home until, in the evening. There is an order in place that says when the parties separate, that my client is the primary physical custodial parent and that Mr. Lopez has alternate weekends. Mr. Lopez also has Wednesday overnights, and then the standard front of the court handbook parenting time outlined therein. That's what the order says, Judge. So to put her out of the house, I think would cause more disruption. If the court wants to order a mutual restraining order, parties to be civil, I'm certain that my client will comply with that. And we leave it up to the discretion of the court. But we're ready to provide what it is that we are able to provide based on what I've stated earlier as it relates to Mr. Lopez thwarting my client's efforts to provide the discovery requested. This guy's making over $100,000 a year, and he's playing these kinds of games. And we certainly need an order from the court to put a stop to that.
Anything further, Mr. Huggable?
Yes, Judge. Judge, we're 6 months into this case. That's my second motion in this case. I've not had a single motion from the plaintiff other than objection to the recommendation by the front of the court. To make these claims now, 6 months into the case, seems disingenuous. Mr. Navarro said he objected to my interrogatories. Look in the court file, Judge. If there's objection, I have not seen it. I've not been hurt or heard anything from it. I can go through my file, Judge, tell you every time I tried to contact plaintiffs by email, telephone, USPS, unresponsive, Judge. Mr. Navarro says that there was an incident at a neighbor's house. It's in his answer. Please tell me what paragraph your answer that was in. I did not see that. To sit here now after 6 months and make my client out, Mr. Lopez, out be a bad guy when you've done absolutely nothing for 6 months, made no complaints for 6 months, is disingenuous, Judge. So we're asking the court to follow the order. My client's hardworking. He's trying to get through this the best he can. This should be a very simple case, Judge. We have to sell the marital home. We have to divide the personal property and come up with a parenting time schedule. That's all we have to do in this case. But we've received nothing from plaintiff to this point. I don't know if the issue lies with Mr. Navarre or Ms. Lopez, but nothing's been done, and we've been attempting to try and get it. I've asked Mr. Lopez, please open the lines of communication. Please let me know why you won't talk to me. So that's what we're going to ask for a motion, Judge, to either set this for a hearing or grant the motion.
All right. Well, there's no way I'm going to grant either party exclusive possession of the property without conducting an evidentiary hearing. I'm hearing allegations essentially blaming the other for the behaviors that have occurred in the front of the children. I am most concerned with hostility between the parents in the presence of the children. And when we've got two parents who are as contentious as these two appear to be, and I'm not putting the blame with either, I'm just saying that atmosphere exists and it's being played out in front of the children, is of great concern to the court. Divorce separation is hard enough on children, even when it's peaceable. When it's volatile, as I'm hearing, it is extremely damaging to children. Children are hardwired by their creator to believe that both parents are good. When parents behave badly, kids don't blame the parents. You know who they blame? They blame themselves. I must have done something to make daddy angry. I must have done something to make mommy angry. This is my fault that mommy and daddy are fighting. They don't understand it. They can't process it. It's extremely damaging. So I've got a situation with two parents who can't get along, regardless of whose fault that might be, and I suspect the fault is shared, which it normally is, living in the same home. And a situation where if I put mom out, where am I going to put her? How in the world is she going to be able to pay for a place to stay for herself and her children? It just doesn't make sense. Without an evidentiary hearing, I'm not putting either parent out. Mr. Navarre suggested a mutual restraining order. In fact, before he even said that, I started writing down what a mutual restraining order would contain. It would prohibit both parties from harassing, threatening, intimidating, assaulting, or threatening. I think I already said threatening. The other. And it would prohibit them from arguing in the presence of the children. And then I can enforce it by my contempt power. When you have a disagreement, go to your separate corners, leave the kids out of it, try to have a peaceful conversation, try to resolve it. But angry outbursts in the presence of the children are simply unacceptable. Just keep in mind how extremely fragile they are right now, given all that's going on. Think of them, put them first. Put them ahead of your contempt for the other parent. Put your children first. The order should also minimize the contact that each has with the other. So fortunately, Mr. Lopez has gone working during the day, which leaves mom there to care for the children. No opportunity for arguments then. But in the evening, when Mr. Lopez is home, this is when we're going to have the potential. This on weekends, when they're there, this is when the potential for conflict is going to occur. And I am ordering mediation. I see in Mr. Navarre's response that you both agreed to the mediator in Brighton. Let's get this rolling as quickly as you can and figure out what's going to happen and figure out a path forward so this volatile condition in front of the children is eliminated. This just can't happen. When one parent acts aggressively, the other one needs to walk away. I don't care who's the one initiating it. The other one has an obligation to walk away from it. I don't want either one initiating it, and I'm not giving them carte blanche to do that. But I'm saying to each parent, if you see the other parent getting worked up, walk away. Just walk away. Allow things to cool down a little bit. Try to have a civil conversation outside of the presence of your children. And let's get this thing mediated. I'm not ordering any kind of sanctions today. The mother's reason for not replying to discovery is, at least based on the response, in a large part, based upon the fact that she doesn't have access or didn't have access to things that Mr. Lopez removed. I don't remember what it was, a hard drive, a jump drive, whatever, a thumb drive. Yeah, I don't know if that's true or not, but if indeed it is true, it would explain why she hasn't been able to reply timely to the discovery. But I want the discovery, whatever you got, supplied as soon as possible. I want you to get in front of this mediator as soon as you possibly can. All issues on the table, and let's figure out a way to live peaceably until a final resolution can be reached as to the disposition of the home. If your mediation is unsuccessful and there are continued behaviors of either party within the home that violate the mutual restraining order, I will indeed schedule an evidentiary hearing. We'll get to the bottom of it. But it's far better if they could just simply learn to restrain themselves until this matter can be resolved. So I'm denying the motion for immediate possession. I'm ordering a mutual restraining order prohibiting both parties from harassing, threatening, intimidating, or assaulting the other, from arguing in the presence of the children. I'm ordering that they minimize their contact with each other when they are both in the home. I realize that's not a precise measure that will be hard to enforce, but if I see clearly that one or the other is indeed not minimizing, but maximizing by forcing themselves into disputes and conversations, I will not hesitate to hold one or the other or both in contempt if that's necessary. And I'm ordering that you move forward with all deliberate speed in your exchange of discovery and in the scheduling of this matter for mediation. Mr. Navarre, you'll prepare that order?
It's Mr. Hogaboo's motion, but if Your Honor wants me to prepare it, I'd be happy to do so, Your Honor.
I denied his motion, Mr. Navarre. I would say you were the successful party. You could prepare the order.
I'll get that submitted on a consent basis, Your Honor.
Thank you.
Thank you, Your Honor. Thank you, Mr. Hogaboom.
Phil, I contacted Rick Trost yesterday. He did not give me an answer back. I'll contact him again today. We'll get some dates scheduled. I should have dates for you today, hopefully today for mediation. Okay.
Hopefully we can lock that down today, Bill.
All right. Thank you. Thank you, Judge.
Yep. Thank you, Judge.
Have a good day, gentlemen.
Thank you.
Thank you, Your Honor. You as well.
Thomas, I'll talk to you in a few minutes, okay?
Thank you.
Okay, let's see. What do we got next?
to the next case.
I don't see Susan Danke here yet, so let's hold off on that. Oh, that's the status conference. Oh, okay. Let me bring Mr. Navarre in, or Mr. Fallahy in. Rather. So, Mr. Fallahy, I see that I've got a judgment of divorce in the Netto matter.
Yes, Judge, and I just had emailed Dawn. We were waiting on one signature page for the uniform child support order, which I just emailed over to Dawn a few minutes ago, and it appears she may have just walked in with it.
Yes, indeed.
Great.
Yeah. Thank you. All right, I'm going to sign these and we'll make sure we get them back to you.
Thank you,
You're not
sir.
expecting Ms. Danke to show up this morning? She's not in the waiting room.
No, she was not planning to appear.
All right, all right, I'll set that aside and I will sign it all and get it back to you.
Thank you, Judge. I've also
Do
got
you
a
have anything
930
else?
Procon.
Oh, I see that. Well, since I've got you here, why don't I take care of that? Amelia Gamel, and I see Kieran Gamel is here. Let me get him in. Okay, and I'm sorry, is it Gamel or Gamel? Gamel, sorry. I know you just told me, but that's how long it stayed in my brain, Mick. All right, Shannon, Mr. Fallahy's here on behalf of the plaintiff, and both the plaintiff and defendant are present. Ms. Gamel, would you raise your right hand, please? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your full name for the record.
Amelia Layton Gamel.
Go ahead, Mr. Fallahy.
Thank you, Your Honor. Amy, can you hear me okay?
Yes, I can hear you.
Okay. Do you remember signing the complaint for divorce in this case?
Yes.
Were the allegations, also known as the statements in the complaint, true when you signed that complaint?
Yes.
Do they remain true today?
Yes.
Specifically, you feel as of today there's no chance for reconciliation of your marriage. Is that correct?
That's correct.
And I have to ask, but are you pregnant at this time?
No.
You and Kieran, who's also on the Zoom call here, have signed and dated a consent judgment of divorce. Is that correct?
Yes.
And do you feel that that would be a fair resolution of all of your assets and debts that you accumulated during the marriage under the circumstances of this case?
Yes.
And after you're done with your testimony today, are you requesting specifically that the judge sign that?
You blacked out at the end.
Sorry about that. After you get done with your testimony here today, are you specifically asking the judge to sign that judgment and finalize this case?
I am.
Thank you. I have no further questions, Your Honor.
Mr. Gamel, do you agree that this is a fair and equitable resolution of the issues involved in this divorce proceeding?
Yes.
And you've consented to the entry of the proposed judgment of divorce?
I have.
I'm satisfied based upon the proofs that there's been a breakdown in this marriage to the extent that the objects of matrimony have been destroyed. There remains no reasonable likelihood that the marriage can be preserved. I have signed the judgment of divorce and will make sure that each of you receive a copy of it.
Thank you very much, Judge.
Thank you. Have a good day, folks.
Thank you.
Okay, I'm just going to let the rest of them in since I can't tell who's who.
Did you sign the Dow too?
Yes.
You did. Okay.
Yes, I gave them both back to Dora.
Okay.
Okay, Samuels versus Samuels. Let's see. We have Vanessa Samuels present. Is Desmond Samuels present? I've got two iPhones in here. Or I'm sorry, two phones. One ends in 4 zeros. What is your name? Uh, 734 phone number. What is your name, please? Well, I have no idea who that is. If they're not going to answer, that's kind of hard for me to know. I have an iPhone. I have no idea who that is. Can you tell me your name, please? Okay. I've got two unidentified phones in and they're not answering, so I guess I'm not quite sure how I handle that. But in any event, Ms. Samuels, it does not appear that Mr. Samuels is present. Where is he employed?
At Certainty.
Oh, okay. I've got someone else in the waiting room. I'm going to bring them in. Again, I have no idea. If you folks don't put your name in the screen or identify yourselves, I have no idea who you are. All right, I just let somebody in with a long, strange identification. It starts with the letters DMQ. What is your name?
My name is Catherine Fouch.
All right, hold on a minute. I'm going to rename this. And I'm going to put you back in the waiting room.
Okay.
Oh, and I see maybe the problem with the iPhone is they're having trouble with the connection. Okay, I just made a connection with an iPhone. What is your name, please?
Yes, Richard Harris.
Richard Harris. Mr. Harris, I'm going to rename this so I know who you are, and I'm going to put you back in the waiting room until I call your case.
Yes, sir.
Hello.
Okay, and your name is Demita
Harris. Yes.
last name?
Harris.
Oh, okay. All right, Ms. Harris, I'm going to put you back in the waiting room and deal with another matter, and then I'll bring you and Mr. Harris back in as soon as I'm ready to call your case.
Okay. Okay.
Okay, so Ms. Samuels, your case is scheduled today for a pretrial. What I determine at a pretrial is whether or not there's going to be a need of a trial. In a divorce case that involves children, the issues that would normally be addressed at a trial are custody, parenting time, child support, and division of property. I see that you and Mr. Samuels have a consent stipulated custody parenting time order in place. Does that seem to be working out for both of you?
Yeah, it's fine.
All right, and you would expect then that the final judgment of divorce would contain these same provisions?
Yes.
Do you and have you and Mr. Samuels divided all of your personal property?
Yes, we have.
And do either of you own any real estate?
No.
Okay, so it won't be necessary to have a trial as long as you can get me a judgment of divorce.
Okay.
The packet that you received when you started your divorce proceeding should have a blank judgment of divorce in it. So you would fill that out. You and your husband would both sign it, and then you would need to take it to the front of the court to get it approved.
Okay.
We want to make sure everything that's supposed to be in it is in it. I'm going to take some proofs today that will allow me to sign it when you bring it back to me. So if you could raise your right hand, please. You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
State your full name for the record.
Vanessa Samuels.
You can put your hand down now, ma'am. Ms. Samuels, you filed a complaint for divorce a little over 6 months ago. Was everything in that complaint true at the time that you filed it?
Yes.
And is it still true today?
Yes.
It appears from the temporary custody order that there was one living minor child born or adopted during your marriage to Mr. Samuels, Deshaun Dominic Samuels. And there are no other minor children born or adopted during your marriage.
No, sir.
Are you pregnant today?
No.
Is there any possibility of you and Mr. Samuels reconciling?
He done had a whole other baby with somebody else. Probably not.
Probably not. Okay.
Probably not.
I am satisfied, based on your testimony, that there has been a breakdown in your marriage, that the objects of matrimony have been destroyed. There is no reasonable likelihood the marriage can be preserved. I will sign that consent judgment of divorce as soon as you present it. I'm going to keep your trial date on, as long as you get it to me on or before that date. And let me see when that is. Usually they write it in. Oh, here it is. Yes. February 4th. As long as you can get that back to me before February 4th, approved by the front of the court, I can sign it and you will be divorced.
Okay.
Did you have any questions for me?
No, sir.
All right. Good luck to you, ma'am.
All right. Thank you, hon.
You're welcome. Have a good day.
You too. Bye-bye.
Bye.
All right. Okay.
Okay, this is a matter of Harris versus Harris, and both the plaintiff, Demita Harris, and the defendant, Richard Harris, are present. Good morning, folks.
Good morning.
So your case is scheduled for a pretrial today, and at a pretrial, I determine whether or not it's going to be necessary to have a trial. So let me ask you, I see that the two of you entered into a stipulated order for custody, parenting time, and support. Does that seem to be working out for you?
Yes.
Yes.
And you would expect those terms to be included in your final judgment of divorce?
Yes.
Yes.
Have you already divided all of your personal property?
Yes.
Do you own any real estate?
No.
All right. So if you will, I'll take some proofs here in a moment, ma'am.
Okay.
But if you would prepare a consent judgment of divorce, the paperwork that you received when you initiated your case should have a blank judgment of divorce in it. You need to fill that out. Simply include the terms of the temporary order in the judgment.
Okay.
Fill out the other appropriate boxes. Take that to both of you would sign indicating your approval.
Okay.
Then take that to the friend of the court, and one of the referees will review it and make sure that everything that's supposed to be in it is in fact in it. And
Okay.
then you just bring that back to me, to the courthouse, and we'll make sure that it gets signed. And as soon as it's signed, you'll be divorced.
Okay.
So, Ms. Harris, I need to take some testimony from you. I want you to raise your right hand, please.
Okay.
You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
State your full name for the record.
Demita Pauline Harris.
Ms. Harris, you filed a complaint for divorce a little over 6 months ago. Was
Yes.
everything in that complaint true at the time that you filed it?
Yes.
And is it still true today?
Yes.
So it appears from the temporary order that there are 2 living minor children born or adopted during your marriage to Mr. Harris, those being, I'll probably not pronounce them, Jadid and Femi.
Yes. Femi is 13. Yadi's 18 now.
Oh, Yadi's 18. Okay, he doesn't.
Yes.
And is he done with school?
Yes. Yadi will be graduating in June.
All right. Well, normally we retain custody until the child graduates from high school or they're 18 and no longer attending school. So I think we'll still need to keep him in the judgment, even though he is 18 now. But he will drop. I'm sorry.
Okay.
As soon as she does graduate, then she will drop off the support order and will no longer be subject to any parenting time, anything like that. Okay?
Okay.
Okay. All right. Are you pregnant today?
No.
Is there any possibility of you and Mr. Harris reconciling?
No. No.
Okay, so I'm satisfied based on your proofs today that there's been a breakdown in the marriage with no possibility of reconciliation. If you will get that consent judgment of divorce to the friend of the court so it can be approved and then get it back over to the courthouse, I will sign it, and at that point you will be divorced. You're currently scheduled for trial on February 4th. So as long as you get that back to me before February 4th, there's no need for you to appear on the 4th.
Okay.
Do either of you have any questions for me?
No, sir.
Oh, no, sir.
Okay. I will watch for that judgment of divorce. Have a good day.
You too.
Yeah.
Thank you.
Yes.
You're welcome. Okay, and next up is the case of Fouch versus Fouch. We have Catherine Fouch present, and I see I misspelled your name when I put it in the, we just lost her. She must have hit the wrong button. I'm sure she'll be right back. me see if I've got a phone number. I do. I'm going to try to get her on the phone. Well, didn't ring through. Shoot.
Hello?
Catherine Fouch?
Yes, this is.
All right, we lost you from the courtroom. I don't know what happened, but I can do this by telephone. That's fine.
Okay.
Okay, your case is scheduled for a pretrial conference this morning. And what happens at a pretrial conference is I try to figure out whether or not there's going to be a need of a trial. It looks like you and Mr. Fouch were unable to reach agreement on a temporary order, so you're currently operating under one recommended by the conciliator. Does that seem to be working out for you?
Well, we actually kind of have an agreement. We're both still living together, and we're both just co-parenting, so there's not really specific parenting time right now.
Okay, so that's what the order says, so that's what you're doing, correct?
Yep, correct.
And you still want to be divorced?
Yes.
Okay, so is it your intent to continue to live together even after you're divorced?
I believe our intent is to sell the house that we currently both co-own, and then once the house sells, split the profits from that and then go our separate ways.
Okay. And then once you do go your separate ways, you're going to have to figure out what custody and parenting time is going to be. Do you think you'll be able to do that?
I believe so, yes.
Okay. So if you would put your agreement in the form of a judgment of divorce,
okay,
and both of you sign off on it, get that approved by a referee at the front of the court, and then get it back to me. I can sign it and you can be divorced.
Okay.
You should have received a blank judgment of divorce at the time the case was started. And you just get that filled out. Both of you sign it, get it approved by the front of the court and back to me, and then I can sign it. I'm going to take some testimony from you this morning. I'm going to ask you to raise your right hand, please.
Okay.
You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
State your full name for the record.
Catherine Marie Fouch.
Ms. Fouch, you filed a complaint for divorce a little over 6 months ago. Was everything in it true at the time that you filed it?
Yes, it was.
And is it still true today?
Yes.
It appears from the temporary order that there's 3 living minor children born or adopted during your marriage to Mr. Fouch, those being Tyler, Eric, and Adam. Is that correct?
Yes, it is.
And there were no other children born during the marriage?
The children were born before the marriage, but no, there was no children born during the marriage.
I got you. Are you pregnant today?
No.
Is there any possibility of you and Mr. Fouch reconciling?
I don't believe so.
All right, I'm satisfied based on your testimony that there has been a breakdown in your marriage. To the extent the objects of matrimony have been destroyed, it remains a reasonable likelihood the marriage can be preserved. If you will get a consent judgment of divorce approved by the friend of the court to me before February 4th, which is the date of your trial, there will be no need for you to appear at a trial.
Okay.
Did you have any questions for me?
To get it approved by the friend of the court, I just need to fill it out and then is there like a fax number to send it to, or is that something I can find online?
You have to actually take it to the friend of the court. They have.
Oh, I have to bring it there?
Well, you can try calling out there and ask if they'll accept it by email or scan or fax.
Okay.
That's not a process I'm involved in.
Okay.
And if they tell you they can, I'm fine with that. But typically what happens is you actually physically take the form that both of you have approved to the friend of the court, and then at the front door, they will take that from you, get somebody to review and approve it, and then return it to you so that you can bring it back over here.
Okay.
Okay, well, good luck to you, ma'am.
All right, thank you so much.
You're welcome. Have a good day.
Okay, bye-bye.
And let's see, that takes us to Bing Blum, which should be fun.
We must have just kept missing each other.
I think so.
'Cause I just got back from across the hall and then I looked and there you were.
Okay, so let's see. Oh, I left my stream on. Didn't realize that. Thought I'd shut it off. Must have gotten distracted. Okay, so we're not on the record yet, but it doesn't look like we've got a complete set of folks here. We got Mr. Smith, but we don't have Ms. Reynolds. We got Ms. Brown, but we don't have Mr. Brown.
Mr. Brown's in jail, I believe.
Oh, he is.
Yeah, he's been there for some time, I believe.
Well, we can certainly have him. Do you know which is he on, Wesley or Channer Road?
That I don't know. I know it might be Channer because I think he's being held on his criminal cases till at least Matt, wasn't it like February something?
Yeah, I think he's got a pretrial in February. Let me try to look it up on the jail roster.
And you're right, I'll just need a brief moment with him to try to see if we can take care of this matter. So,
of course. Do you have an
Looks like he's at
extension
Chanter.
Yeah.
You have an extension for whoever the contact is out there to have him brought into the meeting?
I'm pulling up their number right now. Looks like 1609 is the extension.
What's here? Yeah, Matt, I don't think that extension was right. That's for family members to call in.
Oh, Well,
Do they
the
have
other
a
number
booking?
listed is for the sergeants is 1606.
Let's try that. Deputy Carpenter, this is Judge LaFlamme. Are you the person to call if I need to have someone brought to a Polycom? They are. I just got confirmation. Corey Brown. Right now, if we can. Yeah. All right, and I don't remember what extension I dialed. It says 4927 on the display. Is that the correct extension? 1608. Okay. I'm going to write that down so I don't have to go looking for it next time. I'm not sure what the extension is in the courtroom, but if that's what it's reading, that's probably what it is. All right, we'll just watch for them on the in the meeting room. Thank you very much. Yep, bye-bye. Okay, they are going to be bringing him in. He didn't indicate how long that would take. I'm guessing a few minutes anyway. Shannon, let's go on the record in Reynolds versus Smith. I'm not sure where Ms. Reynolds is. She normally participates, but the purpose today was me to figure out what I'm going to do with Mr. Smith for purposes of my contempt sentence. I learned, I'm sorry, Mike Rosenthal on behalf of Mr. Smith. Mr. Smith is present, and Matt Way for the petitioner. So I learned, I think yesterday, that they're not doing weekend visits at jail. They don't want people coming and going and infecting the population. But I also learned that there's a possibility of a tether. So, Mr. Way, how exactly would that work?
Your Honor, I'm not usually involved in the tethers much. I know it requires I think like a weekly or monthly fee. I just heard from the captain of the jail. He when I was asking him about what they were doing, he informed me that they do have tethers available. Mr. Rosenthal might actually have a little more experience with that with some of his clients.
Oh, sorry. Go ahead, Your Honor.
I know there is a fee involved. I'll have to explore that. Who monitors the tether? I mean, I was under the impression that there would be somebody from probation that monitors for whoever happens to be assigned to them, or is there someone from the jail that actually monitors those?
I think it's typically actually, I don't know I don't know the logistics, but I think they may be contracted through one of the bail's bondsmen, and they're the ones that monitor is generally how it works.
And so if I were to order Mr. Smith to a house arrest, limited to going to and from work, to and from his mother's home for purposes of picking up and dropping off his child. There's somebody who keeps track of where that tether goes to know whether or not it's been violated.
That's my understanding, Your Honor.
Yes, mine too.
I think that's an effective way to allow Mr. Smith to keep his job. I mean, we're pretty much locked down anyway, so currently there certainly is some restriction on his freedom, which is what I want to achieve. So merely suspending a sentence doesn't seem to do any good. There's got to be a cost involved in violating my orders. And I think that's an effective way to do it. Anything further, Mr. Way or Mr. Rosenthal, on this issue?
No, Your Honor, I would leave it to the court's discretion.
Your Honor, I agree with the understanding. I would also ask the court to at least allow him time to do the things he needs to do in terms of grocery shopping and stuff like that. That it's not just limited to go get his kid and to go back and forth to work, because he does actually have to live a life as well in terms of going grocery shopping and doing things like that.
Mr. Smith, who do you currently reside with?
My girlfriend, Lindsay Cunningham.
Any reason she can't do the grocery shopping while your freedom is curtailed?
Yes, she can.
All right. And obviously you got to get gas in your car. Do you currently have a driver's license?
Yes.
Okay. I thought I remembered a time in the past when you didn't, and my memory could be wrong on that. Is there a gas station on your way to and from work?
Yes.
That's perfect. So what's the work address?
My work address? I'd have to look it up.
You work for Hilux?
Hilux Controls in Litchfield, Michigan.
All right, I can find that. Do they have more than one facility in Litchfield or just one?
Just one facility. Well, they have two facilities, but they're right next door to each other.
Okay.
So.
And what's your home address?
It's 11391 Straight Road, Strait, Jonesville, Michigan, 49250.
All right. So what I'm going to do, Mr. Smith, I am going to sentence you to 30 days on tether, limited to driving to and from work and to and from your mother's home for purposes of picking up or dropping off your daughter. And I'm sorry, I'm going to need that address too.
My mother's address?
Please.
4670 Reynolds Road, Jackson, Michigan, 49201.
Okay. Yes, go ahead.
Sorry. I have a doctor's appointment tomorrow. I have to get my cast off.
This won't start until you actually get the tether, and it's going to take me. What I will do is I will issue an order that has some very specific directions in it for where you get this tether, and I just need to follow up and get some more specific information. So that's addressed, and it won't start. The sentence won't start until you actually have the tether, because obviously you're going to have to drive in and be able to pick it up, and it will permit that. But I've got to get details on that so that you're not left wondering what it is you're supposed to do. It'll all be specifically spelled out in my order.
Okay.
And I will tell you, Mr. Smith, you absolutely cannot violate this tether. if you do, I've only got one thing left, and that's to sentence you to an extended stay in jail. And I'm sure you don't want that, and I'm sure it's not going to be beneficial to your child. It's not going to be beneficial to Ms. Reynolds, since if you lose your job, she's not going to get any more child support. But that's all I got left. That really is all I have left. I sure hope you don't force me to exercise that option.
I go ahead. I'm sorry.
I was going to change subjects, so if you have more to say, go ahead.
I just wanted to say, when I went down to Georgia, I promised myself that I'd never go to jail, and I really don't want to go to jail again. It's the reason why I got out and I stopped talking to her, and you know, it really changed me. I had COVID down there, and on August 15th, I had COVID, and you know, I really thought I was going to die in a jail cell, and I don't want that to happen. I think of nothing else but my baby girl, and it's just, I'm sorry for this, Your Honor.
That's encouraging to the court to hear that. You'll be getting an order from me. What I was about to say is I was hoping that Ms. Reynolds would show up this morning, because I wanted to wrap up the remaining issues regarding your parenting time and denials. I was informed by the friend of the court that there were 2 more parenting time complaints that you guys filed relating to the Christmas holiday. And I told them not to schedule those. I would address them this morning. Since she's not here and she wouldn't have known that I was going to address that this morning, what I will do is schedule another hearing at some point in the future where I will address all of those issues and get them all finally wrapped up. Okay?
Okay. Yeah, all those issues. Okay.
Okay. Mr. Rosenthal, you're on this next matter as well?
Yes, Your Honor.
Okay, let me get rid of Mr. Smith. And I see Channer is signed in. Let me get him in the room. As soon as we have a connection, what I will do is create a breakout room and put you and Mr. Brown in it.
Thank you very much.
At least start getting that set up now.
No plaintiff present?
Plaintiff is present.
She is, okay.
Mr. Wade, did you want an opportunity to speak with the petitioner? Matt, you're muted. All right, well, in the meantime, I still don't have a connection, so I'm going to wait till there is one. I don't know how easy it is for him to press the button to go into the private meeting room. Let me see. As soon as we have a connection, I'll do that. There we go. You are Corey Brown?
Correct.
All right, Mr. Brown, I'm going to put you and your court-appointed attorney into a breakout room where the two of you can have a private conversation. It does require you to enter something at your end. You should get a command on the screen. If you have trouble being able to do that yourself, ask the deputy to help you.
All right.
All right, and Mr. Way, I'm going to go ahead and open a second room for you and the petitioner.
Thank you, Your Honor.